Today, we're going to hear lawyers or people from the legal field. And while it's not the only way to look at responsibility, it is a way that a lot of people think about responsibility in, and it makes sense. And at least the initial reason that I had in mind was, well, see what happened in the US, and a new president immediately talked about a lot of stuff. One of them was, hey, let's cancel the AI regulations, let's allow the market to be free and so on. And these are social, economic, and legal, and other, there's so many ways to think about it. And so for that reason, today we have three legal experts, and we'll hear and get some ideas of how American law might look at that, European law, Israeli law. And while it's not just going to be a legal debate or discussion, it will have some heuristic taste to it or smell to it. And I think it's good to have that in mind. So without any further ado, I'd like to present our speaker, our first speaker. I always present very shortly, not because there is so little to say, but because each and every one of you have done quite a lot. So Professor Glenn Cohen is a professor of law at Harvard Law School and faculty director at the Petrie Flom Center for Health Law Policy, Biotechnology, and Bioethics. His work on AI ethics and regulation has been widely published in Nature, Science, New England Journal of Medicine, and several books, including one of the recent ones, the 2024 Research Handbook on Health, AI, and the Law. I think it's available online, actually. Right. And Professor Cohen also served as a consultant for the World Health Organization and various government bodies and in AI governance and bioethics. Glenn, the floor is yours.
תודה לאורן ולילה טוב לכולם. סליחה, אבל כאשר אני מדבר על ה-AI, אני צריך לדבר באנגלית. But my father would be very happy because he always reminds me how much he paid for Hebrew school. So every time I use it, it's like a little interest payment. All right, so let me just share my screen. One sec. Okay, here we go. So these are just to start, some disclosures, nothing too exciting, but always good, I think, to start and to be just open about that kind of stuff. I thought I would just start by, and let me know if anything goes wrong, always with tech, that's the first rule. Thought I'd start by just talking about some examples about what we're talking about when we talk about the field of medical artificial intelligence. Examples include, and these are all real world examples currently in use in the United States, using AI to determine whether colonic lesions from a colonoscopy are malignant or benign, in vitro fertilization, determining what the correct or the proper dose of follicle stimulating hormone should be for a woman seeking to produce eggs. There's currently a huge amount of variation, for example. Also using AI to select which embryo to implant for the greatest likelihood of a successful pregnancy. In mental health, we've got chatbots working with adolescents. Some of them have been classified as general wellness products, but the idea is that they are doing something to help with depression for adolescents or giving them an outlet. We have, and this one I find very interesting, the Stanford Advanced Care Planning algorithm, also known as the death algorithm, which Stanford hospitals use to predict 3 to 12-month all-cause mortality as a proxy for when to initiate an end-of-life decision-making conversation or advanced care planning conversation with patients. You have IDXDR, which in 2018 was approved for diabetic retinopathy by the FDA. It's the first autonomous, quote-unquote, FDA-approved device. The idea is that they can make a screening decision without the need for a clinician to interpret the results, and makes it usable by healthcare providers who don't normally get involved with eye care. And then something we're seeing actually really rapidly rolled out in large academic medical centers is ambient listening, or also called ambient scribing, where the AI is recording sessions with patients, producing draft summaries and notes for physicians to review and make their own. We also have AI drafting responses to MyChart, which is a system by which people get results from tests, inquiries and inboxes from patients. So this is the idea of AI doing the first draft of the email response with the idea that the physician will review before they approve. But we know because of automation bias, actually that doesn't always happen, or doesn't happen necessarily at the depth we want. Okay. Another just sort of level setting way of thinking about this is that we've got different verticals from a business perspective where AI is getting involved. The clinical is the stuff we'll probably spend the most time with and is what gets the most attention. But I want to also just draw your attention to the financial side, especially in the United States, where billing and reimbursement is a huge piece of what we do, but also the administrative side. And this might be things like patient scheduling, registering, customer service. And this is a place where there's a lot of adoption because already many hospitals have outsourced these functions to call centers and the like. And part of what's interesting is that I think people normally think the ethical and legally juicy stuff is the clinical, but actually even the administrative use cases, there's some very interesting problems. So for example, when you try to determine how to schedule a physician and how many patients they should be seeing and what level of overlap, there have been uses of AI to try to analyze no-show rates by patients, by particular patients, in order to make sure the physician's time is maximized. But those no-show rates themselves might reflect things like lack of transportation options, bad kind of, home support in terms of a family, difficulty of being unhoused, being disabled and the like. So if you ask the AI without guidance just to optimize along this dimension, you might suddenly have the result that the people who are getting the least time with a physician are some of the people who might have the highest healthcare needs. And then operations, including facilities, so environmental controls, energy consumption, that kind of stuff. All right, I'm not going to spend too much time on this because I think people probably know most of this, but I often like to say the last 10 years have been fueled by machine learning. And before that, though, the prior kind of renaissance that kind of fizzled, the last hype cycle of AI was all about expert systems, where the idea would be we'd follow along physicians and we'd ask them, well, why did you order that test? Why did you ask that question? What were you thinking of this moment? And the idea was translate all of these implicit rules into explicit rules in a program, and we'd get great results. Of course, turned out to be a disaster because humans are very bad at metacognitive tasks. We don't know why we do what we do, and when asked to give reasons, we give reasons that are not the actual reasons. But machine learning has really been absolutely remarkable in what it's able to do. And we'll talk about large language models maybe a little bit later, but in particular, large language models do a really simple task, basically predictive text. And yet, just from this very simple task, have generated a huge amount of output that is very useful. The problem, though, of course, with machine learning is, especially unsupervised machine learning, but even supervised, is that we have training data, we have something we want, and we basically ask the algorithm from the label training data to learn rules, and the rules it learns are not necessarily the rules we want to. And here's just an image of deep learning just to show the idea that there's maybe hundreds of hidden layers that we really can't explain even if we wanted to in deep learning. But my favorite example is during COVID, where essentially everybody was trying to figure out, can I diagnose COVID from an X-ray, especially in the early days when we didn't have good tests? And one hospital system was doing amazing. They fed in all these images of the X-ray. They tried a verification set the AI had never seen. It did amazing on it, until they realized that what happened was that they had a COVID ward and a non-COVID ward, and the X-ray machine was pitched to the left in the COVID ward and to the right in the non-COVID ward. And what the AI had actually learned was, had the X-ray been taken on the left versus the right. So it was doing really, really good at that task, but that was not the task of predicting COVID. And the idea that this is a general problem, I would say, with machine learning, is that, especially more black box or opaque or non-interpretable forms of machine learning, that we really don't understand why it is doing what it is doing, and in some instances that's a problem. Okay, so now just to shift to the kind of focus of today, I'm going to take you through what I view as the key legal and ethical issues and do it in a way that's sort of like building an AI step by step. Now, to be fair, this is not the way computer scientists actually build the AI, but I think it's a conceptually helpful way of walking through it. But before I do, I just want to start with the punchline of the talk today, which is to say, what does the Trump administration mean for all of this? The short answer is we don't know. It's really early, but actually a lot of the stuff that should worry us the most or law cares about the most are not things that were currently under Biden in the federal kind of legislation or the federal agenda. So before Trump came in, the biggest move by the Biden administration was the Biden executive order on AI, which was industry-wide. Mostly what it did was funded various agencies to do certain kinds of work and instructed them to revisit, to review, and the like. But it didn't really do very much at the level of exact implementation. It started some balls rolling, but itself wasn't hard law in the way GDPR or the EU AI Act is. Instead, what I will tell you, and we'll get into this in more depth, is most of the work being done in medical artificial intelligence is being done by state tort law, so liability, some existing but old federal privacy law, the HIPAA statute, some state privacy laws, which tend to be a little bit new but are not focused on healthcare, but instead more omnibus, as well as FDA guidances on the regulation of devices that use medical AI, and then a level of contractual back and forth, typically between developers and hospital systems. There is, I would say, two exceptions where federal law in the last year or so has been powerful. One, they're both about to go into effect, so we'll see how powerful they are. And one of the things I'll tell you is that I'm not sure they will go into effect, and we'll see a rollback. One is the interpretation of what's called Section 1557 of the Affordable Care Act, which is an anti-discrimination provision, and guidance from the Health and Human Services Department that these protections extend to algorithmic discrimination by hospital systems. And then another, which is called, often referred to as model cards, which are kind of like nutrition labels for AI systems, and again, requiring hospital systems using AI, if they're receiving Medicare or Medicaid funding, to actually make available these kind of model card descriptions. Now, of those layers, the state and tort law and the state privacy law, untouched by the change to Trump. The state privacy law, untouched by the change to Trump. The contractual layers, probably also unchanged. Unclear what's going to happen with the FDA. Just this weekend, they laid off a bunch of people at FDA. Also, Troy Tabaz, who ran the FDA Center for Digital Excellence, resigned, as was kind of expected at the beginning of the new administration. They have yet to install, as far as I know, a replacement. And that person has a lot of directionality. It's not clear if they're going to just end that office. Also, there's just a general Silicon Valley ethos of deregulation in this space. We had the Federal Trade Commission, the FTC, making noises about using its anti-discrimination powers here. Unlikely that's going to happen in the next administration. Also, with the removal of Lina Khan, a lot of antitrust questions and competition law policies about foundational models, for example, unlikely to be a lot of enforcement there. And on the Section 1557 question, unclear what's going to happen, except as to individuals who are transgender. There was an interpretation of 1557 that it covered them, and the administration has already taken the position that it's not going to do that. But in general, it's a focus against bias and kind of anything related to bias. The current administration has shown a clear desire to move away. Okay, so now just to go over the issues somewhat briefly, because this is mostly about a conversation, but I just want to set it up. When we think about what the legal and ethical issues are, the first phase is just acquiring the data. Who do you need to ask for permission? What kind of consent? What is the scope of consent? What identifiers do you need to remove? All of that is mostly governed in the United States by the HIPAA statute, and it turns out to be relatively permissive. We have to remove 18 HIPAA identifiers to make it de-identified, but we can get a lot of authorization by patients. And as a matter of course, most hospitals get a sort of rote front door consent. So of all the issues, I think this is the least kind of powerfully where the law intersects. And when the data has to flow outside of the hospital system to someone else, there are various forms of agreements that can be formed and done, and they are regulated a little bit by federal law. But for the most part, that's a place where federal law has set a playbook that's relatively easy to follow. How representative is the data? Is the data diverse and racial in other ways to serve the needs and contexts in which will be deployed? We have a project called the All of Us Project at NIH, which is to get 1 million patients that represent the United States and all of its diversity, and basically have robust data sources for those patients. That has been, up to now, very well funded and done well, slowly, but done well. Unclear to me whether it's going to be continue receiving major funding, but we'll see. Phase 2, building and validating the model. How do you know when a model is good enough to be used on real patients? What standards of validations will be put in place? Who's going to be doing the validating? So here there are some interesting trade-offs between intellectual property on the one hand and transparency on the other, because most of these are not patentable under federal patent law. You can't patent the underlying algorithms. People typically use trade secrecy as their intellectual property. I will also say there's some interesting questions about disclosure here in adversarial attack and liability for adversarial attack. And I can tell you that in the United States, the vast majority of medical AI is not reviewed by FDA. Instead, at best, it's individual hospital systems implementing who are reviewing. Testing in real-world settings. What, if anything, are you going to tell patients about the use of AI? Do you need to have a separate informed consent? Can patients opt out? I will tell you, we'll get into this maybe in a few minutes, I will tell you that essentially much of this, while there is in theory liability for breach of informed consent, none of the cases about AI have ever kind of occurred in this space. And this I view more as a place where bioethical norms than hard law are doing the work. How do we handle liability? More on that in a second. State tort law, some efforts here, although again, not a huge number of cases. And finally, how do we think about regulation in this space? Well, FDA has been the main mover, except for within hospital systems where HHS has had some disclosure. I don't know what's going to happen in the next 4 years, to be perfectly honest, although I think more light touch. Lastly, broad dissemination. When you have a model that works, how do you ensure that there's equitable access for the model, that everybody gets who contributed data gets to benefit? We saw very little hard law on the subject, some bioethical norm setting on the subject in the United States. I would not hold my breath for this to be a major focus of legal work in the next 4 years, in part because we're also having a major cost-cutting moment in terms of healthcare in the United States. Okay, I'll say a few more things and I'll subside. One is just to say, especially in the United States, but anywhere, if you compare the question of AI in healthcare to, let's say, AI and driverless cars, you see that in healthcare, there are a lot of different intermediaries who touch the AI systems. And one way of thinking about the problem from a regulatory design perspective is that if you only regulate at one of these levels, one of these circles, you might end up making things worse at one of the other levels. So developers, their liability, their decision about how to design, regulators, how much should be regulated, what should they look at, questions about physicians and their liability and how their choices about liability might affect their decisions to implement or to adopt, questions about hospital systems who may co-develop or might purchase and how they share data or don't share data and how they monitor implementation, insurers, both payers who have to decide whether they'll pay for whatever the AI recommends or whether they'll insist on going with what the AI recommends when it's cheaper than what the physician wants to recommend. Also malpractice insurers who have to decide what to do for adverse events. All of this is at play. And again, the optimal regulation in the space can easily get it wrong if you up regulation in one space but leave the rest untouched. All right, say a little bit about liability. In the States, the liability question has been almost entirely answered by state tort law. Luckily, when it comes to malpractice, they're relatively similar. We've actually had remarkably few cases on AI medical malpractice. My colleague Michelle Mello has a nice paper in the New England Journal of Medicine where they look at the 20-something cases over the last 25 years. And actually, many of them are not what we typically would think of. Outside of surgical robots, where there have been some cases, when it comes to AI in general, we find very little cases. But this is just a stylized, this colors over here, a stylized attempt to show you a basic proposition of malpractice law, which is you are only liable when an adverse event occurs and you've done something that deviates from the standard of care. So when you're a physician and you're trying to decide, this is the example used as a simple example, standard dose of chemotherapeutics or much higher dose of chemotherapeutics for this particular patient, 3 times or the regular dose. And part of the promise of the AI is it's going to give you a very personalized analysis of this patient. So you're asking yourself, what should I do? Well, if the AI recommends a higher dose, not the standard of care dose, a higher dose, and you follow it, and there is an adverse event, that's a circumstance where you might be adjudged to be liable under medical malpractice. What that means is if you're practicing defensive medicine, if you're worried about liability, this should be your attitude towards the AI. When it tells me to do the exact thing I would have done anyways, it's a brilliant AI. I love this AI. The developers are awesome. When it tells me I'm doing it wrong and I should do something different for this patient, well, that's a liability case. Maybe I'm going to do what I should do anyway. So another way of putting it is to say the design of the liability system has incentives to do exactly the cases where AI is adding value to shy away from those cases. Now, that's not an inevitable feature. There was a period of time when a physician might say, why would I take an X-ray? Why would I take an MRI scan? I can just look at this patient. I know. And today, failing to order the MRI, failing to order the X-ray would be malpractice. So there is a process by which new technologies become the standard of practice, but it tends to be a relatively slow process because we have a lot of respect for the distinct minority in malpractice cases. And unless and until you have major pushes by physicians' organizations, hospital systems, government regulators, we're going to have a period of time where some people will be using AI and some people won't. And essentially, you will not be practicing below the standard of care for a long time if you don't use AI. And that's an interesting problem that you can ask yourself whether we're moving too slow or too fast here. Okay, I'm just going to skip these. We can talk about this during the Q&A. You want to know why cases against developers have not succeeded. If you want to know other obstacles to physicians, including causation. If you want to know about hospital systems, we can talk about that. I want to say two more things and then I'm going to stop. One is just bias. Bias is a huge problem in AI. And I will say the problems of bias, people understand what I call version 1.0 of the problem, which is missing data bias. You are deploying a physician, an AI, to look at moles to determine if they're cancerous. And it turns out you trained it only on Caucasian skin, and you want to deploy it on Mizrahim, for example. And all of a sudden, it turns out it just doesn't have people in that data set, and so its predictions are going to be bad. We can understand that problem pretty easily. The much more subtle forms of bias, and there are many, but the one I'm most interested in is what's sometimes called label bias. And here I'll give you this example from a great paper from a couple of years ago. Basically, we had an algorithm that was actually in place deciding when patients are discharged from the hospital, we want to prevent readmission. We can't do that for everybody by giving everybody a follow-up visit, by having a nurse come to the house. So we want to picture the people who are the most likely to be readmitted. And what did they find in this particular study? There was an algorithm that was being used, and they went back to see who is the algorithm prioritizing. And they found in the United States, it was prioritizing less sick white patients over sicker Black patients. The problem wasn't missing data. The problem was a very reasonable ex-ante design decision someone made, which is to say, we need a variable for which patients are the sickest, the ones in the greatest need. We've got this great data set that shows us the cost of all the patients for the next 6 months after discharge, and we will basically parameterize and optimize along that variable. The problem is the cost curves for American white patients and Black patients are very different because of care-seeking behavior, location, proximity to more expensive medical centers, and also insurance and uninsurance rates. As a result, when you prioritize on cost, it prefers white patients over sicker Black patients. And again, this is not like, in retrospect, after we audited it, this was a bad design decision. But ex ante seems a relatively reasonable one. And if you think outside of the major categories of suspect classification, race, sex, age, you think about all the millions of variables that intersect in this way, the idea of ex ante trying to predict all of these problems and all of these variables and trying to future-proof it seems almost impossible, which is why what we need is more incentives to audit, more incentives to inspect as we go, but you might worry that in doing so, you're going to reveal problems and the incentive structure may not be great. Okay, I think this is my last slide, and then I'm going to stop. Which is to say, a big problem is informed consent. When do patients know that they are even dealing with an artificial intelligence? Do they have a right to know? And if they have a right to know, does the physician have to describe the involvement of the AI in the care as part of major decisions? So I often tell people there's a lot of analogies, and where you fall in the analogies might drive your intuitions. On the one hand, if somebody else, a new surgeon, scrubbed into your surgery and did the surgery, we would say the failure to disclose that, clear violation of informed consent. Is that what AI's involvement in advising physicians on care is? On the other side, when the physician decides whether to advise you to do watchful waiting or to have a lumpectomy to remove something in the breast, for example, a cancerous tumor in the breast, that decision is driven by a lot of things. Among the things that drive it that the physician never tells you are how much you remind him of 7 other patients he's seen, memories of old issues of JAMA, what the last 6 meetings with his colleagues were, how fussy and how kind of demanding he thinks you're going to be going forward, and kind of just how he's feeling that day, maybe what he had for breakfast. So this very serious decision, the black box that made the decision up here, is impacted by all these things. And yet we do not think it is a violation of informed consent to fail to disclose all those things. Which of the two is AI? When we have chatbots being built, and it's so much easier to build them because of large language models, including deep fakes that have the voice and can sound just like another person on the edge, when patients are calling and trying to get advice and trying to understand this, how much do they understand that they're dealing with an AI? And even if we disclose to them that they are dealing with an AI, to what extent does the humanization of AI models confuse them and cause them to actually be less on their guard? In what way do we violate the dignity of persons by treating them, by convincing them they're talking to a patient or making them feel like they're talking to another person, when in fact they are dealing with an artificial intelligence? Or is this just a fetishization of the human touch? Okay, here's where I'll end. If you've listened carefully to me, what I've told you is AI often doesn't tell us what it's doing. It's bad at explaining itself. AI often produces adverse events. And oh, by the way, your AI is often a little bit racist. All of these things are true, but then again, so is your physician. And the real question is, what combination of the AI plus the physician does better? And the short answer is, early on, people were all optimistic that we could make some general proclamations about this. The truth of the matter is, the answer to that question is almost always an empirical question, and the result is almost always a fragile result. But unless regulators are looking and designing systems to answer that question, we're never going to get those answers. Thank you very much.
Thank you very much, Glenn, with even 5 minutes to spare, which will kind of hit you with questions later. But for now, I want to thank you for this very wide scope that you've provided us in a very short time. And I'd like to move along to our next speaker. So my friend, Professor Vera Lúcia Raposo, is an associate professor of law and technology and vice dean at Nova Law School in Lisbon. She specializes in health law and AI ethics, emphasizing on the importance of responsible AI integration in healthcare. She also addresses bias and patient safety, privacy, and the ethical responsibilities of healthcare providers. Her recent publication, which she always chooses the most amazing names. So this is titled The 50 Shades of Black, about black box AI and explainability in healthcare. It proposes strategies to address the black box challenge that you mentioned, Glenn, in healthcare, and it's highly recommended. So, Vera, the floor is yours. It's not really a floor, but I don't know what to say, so the floor is yours.
Well, thank you so much. I'm overwhelmed because Glenn made such an introductory speech, and guys, I can only say like shalom and mazel tov. I'm sorry, I didn't have classes, so I'm very embarrassed right now. But well, let's see if the presentation goes better than my Yiddish. So let me see. Can you see my slides? Even though I work in technology, I'm lousy with that. So since Glenn Cohen talked about the EU scenario, I think it's up to me to talk about Europe. So while all these things are happening, what's going on in Europe, well, in particular in the EU? So as you know, we have the AI Act, right? And the AI Act, it's, well, if you know the GDPR, I used to say to my students that the AI Act is the GDPR with steroids, in the sense that it's so much longer and complex and intricate, and then we are all a little bit lost. The AI Act is based on this that we call the risk-based approach, meaning that the object of regulation, in this case, AI systems, are to be classified into different levels of risk, in this case, to health, safety, and fundamental rights. And then, according with the level of risk, then we have a different legal framework. So you have unacceptable AI systems, which are banned with very limited exceptions, high-risk AI allowed, but with very demanding requirements. And then you have low-risk AI, for which very few requirements are imposed. Now, I will center on high-risk AI systems for the purpose of this conversation, and let me explain you why. Because this is Article 6 of the AI Act, which is the main definition of which kind of AI systems will be classified as high risk. Now, the norms in itself are obviously intricate, but let me summarize 6 number 1. It says that an AI system, either as an independent system or as a component, a safety component of another product, is to be considered high risk if these two things happen, and they are cumulative requirements. So the one in A says that these AI systems have to be already object of regulation by what we call the EU harmonized legislation. So as you know, in many fields here in the EU, the norms are, the source of the norms are not the national lawmakers, but the EU itself, especially in what comes digital. So there is a list which you can find in Annex 1 of the AI Act that deals with, or that lists all these harmonized legislation pieces, which can be either regulations or directives. So this is requirement number 1, be already regulated as an harmonized legislation. And then requirement number 2, which you can find in B, is that in the framework of this harmonized legislation, that specific product must undergo what we call the third-party conformity assessment. You see, the main aim of harmonized legislation is to guarantee that products being offered to the general public in the EU, they all comply with the same levels of safety. And in order to guarantee that, there is a procedure called third-party conformity assessment, meaning that there is someone that attests that, yes, the product complies with the applicable norms. So sometimes for low-risk products, the assessment is done by the manufacturer himself, but often the assessment is done by this third party, which are mostly the so-called notified bodies. So when these two things take place, this AI system will be considered high risk. Now, let me explain you why this is so important. Because in Annex 1, you can find regulations about machinery, elevators, toys, and yes, medical devices. So AI medical devices that undergo this third-party conformity assessment, which, look, I have been done a study, and pretty much all AI medical devices meet also this requirement, will be considered high-risk AI systems. Now, what does it mean, guys? It's for us in the EU does not mean good news, because yeah, the requirements are pretty heavy. You see, when a high-risk AI system is to be put on the market, according with the AI Act, it must first receive the CE marking of conformity, which you might know, this is the blue circle, if you want, that you can find in many EU products. And in order for that to happen, the requirements from Articles 8 to 15 of the AI Act must be complied with. So as you can see, we have loads of requirements. Of course, we don't know how demanding or how flexible will be the interpretation of these requirements. As you know, the AI Act is quite new. The first part of the AI Act just became mandatory on the 2 February. So we don't have the experience to see how administrative authorities, how courts are going to apply these requirements. Well, if things go really bad, the threshold might be so demanding that basically no company will be able to meet them, which is obviously a problem. So for the sake of time, I will just talk about these 3, which also I found the most interesting ones. So let's start with data governance, which is in Article number 10. This is the original version of Article 10, number 3. It's, well, look, training, validation, and testing data, I mean, for the training of the AI system, shall be relevant, representative, free of errors, and complete. Yes, you heard it, free of errors and complete. Well, as you know, this is pretty much a unicorn, right? I mean, where do you ever find such a data set? So luckily, the EU lawmaker understood that this was a little bit utopic, and now this is the current version, more down to earth. So it says, to the best extent possible, yeah, of course, free of errors and complete in view of the intended purpose. So a much more realistic version of the norm. Still, well, we do have some issues, you see, because of the complete here. And the issue is the GDPR. So as you know, the GDPR is by far the most demanding data protection law in the entire world. And I don't say that proudly. It has its ups and downs. I'm not a fan, so to say. Now, the European Commission realized that we had a huge problem with the GDPR. And so it's been launching what they call the data spaces, which are basically bubbles, data bubbles in specific domains where data can be more easily used and reused and shared and, well, pretty much everything. And the one interesting for us, which probably will be the first data space regulation to be into force, is European Health Data Space. Now, this is pretty much done. We have the final version still not published. Don't ask me why. And when they released European Health Data Space, the idea was, well, it's going to be amazing, heaven on earth, butterflies, so much data. I'm not that confident because, you know, this is the EU. This is the land of the people that believe that personal data is the most important thing on the world. And so I'm not that confident. I don't believe that we will solve the issue. And so I find it very difficult that we ever will have this, as far as possible, okay, complete data sets. I see very difficult because the AI Act goes into one path saying we need loads of data to have good AI systems, which is logical. But then the GDPR, and even with the help of this new data space, goes in an entire opposite direction. So I do envisage a kind of a problem. And there are other problems, for instance, regarding data governance control, because here's the issue. Who will assess the quality and and how good and how complete are these data sets? Because right now we have two main candidates. Of course, we have our national data protection authorities, which up until now have been doing this kind of control. But remember that the AI Act will create these new AI authorities also in national member states. Well, I might be wrong, but I will say that there will be a kind of a soap opera because there will be a battle to define who is the boss here, who is in charge. And some national data protection authorities, in particular CNIL, which is the French one, were very vocal in saying that we will be in charge. So yeah, stay tuned for the next episodes. Then another main issue we have regards transparency, which is Article 13 of the AI Act. So transparency in the AI Act has two different meanings. On the one hand, transparency in the sense of disclosing information regarding the AI systems, such as the data sets used to train it, the algorithm, if there are any bias, which of course there are, how were they identified, how are they being addressed? And here's the point. I suspect that many companies, let's say companies that produce medical devices, will want to keep this information confidential because of competitive advantage. I mean, there is the question of IP rights, there is the question of trade secrets. And even though the AI Act states that transparency will not undermine the protection of IP rights and trade secrets, again, I don't see how this is possible. But of course, it all depends on how transparency is going to be applied. And then we have transparency in the sense of explainability. We never use the concept explainability on the AI Act, but transparency is used as a broad concept. So, well, as you know, and Professor Glenn Cohen mentioned that you have the different levels of obscurity or non-explainability. You have the white box, where it's pretty transparent, the AI reasoning. Then you have the gray box, which is somewhere in between, and then you have infamous black box. And in a black box, it means that we don't know how the input data were transformed in an output. And when I say we don't know, I mean me as a layperson, a potential patient, but doctors that use it, authorities that approve the black box system, even AI developers. So it gets pretty crazy, right? Now, the question is, of course, that if the requirement of explainability is to be understood in very demanding terms, it means that black box AI medical devices will not reach the market, which will be a huge loss because the most interesting AI systems that we have nowadays in healthcare are black box systems. Then another concerning norm, which also relates with the talk of Professor Cohen, is human oversight. So human oversight is a requirement for AI systems. I underline what is required for this human oversight. So basically, the human must understand the AI system, again, black box, right? That's a small issue. And must be able to decide if in a particular situation, the AI system is to be used, is to be trusted, and must have the capacity, not only the understanding, but also the power, in the sense of the power within the organization, the authority, to switch, to press the switch off button, right? And in the case of AI, that means that if this human doesn't do that, there might be issues not only in what regards the violation of this norm, but also potential issues of medical liability, because it relates with the medical standard of care. And this has been a huge problem. I have lots of talks with doctors around the EU, and the two main questions: how we will use AI? Are we going to become a target? Who is going to be liable? Me as a health professional, the manufacturer? There is a huge confusion right now, which I suspect might undermine the full usage of AI systems within the EU. Then, of course, we have another elephant in the room. How will the AI Act correlate with medical device regulation? By the way, just a clarification, I found it pretty amazing that we are discussing, the Da Vinci robotic systems and all these pretty fancy AI systems. And in the beginning of last century, those were the very fancy medical devices that we had, right? Which a huge step for our civilization, so to say. And the main issue here is that many parts of the medical device regulation kind of overlap with the AI Act. So one of the main concerns regards the third-party conformity assessment, which I mentioned before. It's a requirement under the AI Act, but the question is that it's also a requirement under the medical device regulation. And here's the question. Are we talking about one single assessment that joins together the requirements of both the medical device regulation and the AI Act, done by one single notified body? I think this is the idea, and by reading the AI Act, I do believe this is the main idea. But in many situations, it might not be viable, because you might have a notified body which is not accredited to make the two assessments, because you do need the proper accreditation for that. It's not simply say, look, I'm a notified body. No, you need to have an accreditation for that. And if that is not the case, and you have a medical device company, an AI developer that manufactures medical devices, that is looking for the CE marking of conformity and cannot find one notified body able to do both, guys, this might turn a never-ending story. So long the entire process. It will be really expensive, really complex. You might have different decisions from different notified bodies. Again, it will not be heaven on earth, that for sure. So I will finish because I'm running out of time. These are some of the things I've published. By the way, where is it? Let me show, yes, with Professor Glenn Cohen in his book. So let me highlight that. And this is my upcoming book on intelligent medicine, hopefully this year. Let's see how fast I can work and how little I can sleep with Brill. Now, people always ask me, is DU, and I will leave with this question, is DU up to this challenge? Because quite frankly, it's quite a challenge, right, to deal with this AI Act. And well, I also don't have a good answer, but I think to myself, I mean, we are Europe. It's the land of the Roman and the Greek civilization. It's the land where people are so crazy that they love soccer more than they love their moms. It's the land where it's very normal to have dinner at 10 p.m. and where we have wine at every single meal, because we are Europeans. So I'm confident that we are up to the challenge. Thank you so much.
Thank you so much, Vera. I think no digital twin could make us so excited about any presentation, at least with the current abilities of different systems. And I'm kind of scared to think what would happen when it would be different, when we get excited by something that is completely artificial. But I think time will tell. So I had so many legal thoughts in mind, but I think I got so excited by your ending slide. And I think it's a good time to, after seeing some of the experience in the EU, I mean, a year ago or 2 years ago, people talked about how the EU is taking a risk here, and let's see what happens there, and then think about what we should do in other places. So I'm kind of wondering how our next guest will see that, talking about the Israeli perspective, and I'm really happy to present our next speaker. So Advocate Tamar Tavory, maybe not in a long time from now, also she'll have her PhD, so we'll add a doctor to her title, but some work to be done there yet, right? So she serves as of counsel at Arnon Tadmor Levy law offices, advising leading international law firms and global pharmaceutical companies, medical device manufacturers, and health tech startups in Israel and in other countries. She's currently pursuing her doctorate. Her 2024 publication, Regulating AI in Mental Health, Ethics of Care Perspective, I really recommend it. I think we talked so much about responsibility or about liability, actually, and risks and so on. And I think thinking about the ethics of care and some aspects that are not as easy to calculate is something also to think about. So I really love this paper, and it's a part of a special issue of the Journal of Medical Internet Research, Mental Health, that focuses on responsible AI in mental health. So with the disclaimer that Dr. Amir Tal, myself, and Dr. Toros co-edited this special issue, I really recommend taking a look if you're interested in AI in mental health. And Tamar,
Thank
the
you
Zoom
so
is
much for
yours.
your kind words. And now let's see if I manage the technological assignment of task or sharing my screen.
Yes.
Are we on the same page? So first, I want to say that the former presentations were magnificent, and there's a little comfort in knowing that everybody around the world are, facing the same challenges. And now I will have to show that we don't do so well in actually answering those challenges, but we'll do our best. And I also want to note that we have special experts around the audience, experts in Israeli law. So please, everybody, feel free to chime in and either point me wrong or just add to the discussion. So with this, I want to say that Israel is very much known for its innovation, for its AI development, for AI in healthcare. There have been some great achievements here, especially due to the special structure of the health system, which is the national health system, and having data digitalized for, I think, more than 25 years. But we, as much as we're good in innovation, we're not so good in regulation. This is also part of the tradition of this country, unfortunately. I knew something would go wrong. Okay, let's see. Do you see the next slide? Just so I'll know that we're on the same
How does
page.
Israel? Yeah.
Good. So really, in Israel, we do not have an AI-specific law, and there's a great dependency on what happens abroad in the USA or in Europe, mainly because digital health startups, companies, and even the Ministry of Health look up to the USA or the FDA, and then the European or the EMA and the CE regulators, and follow them. So we really, I think there's a tendency here not to try to create a new, unique law, but try to look into what happens globally and adapt. And what we have for meanwhile, because I think we're in some sort of transition period, right? Things change in the States, and in Europe, the EU the EU AI Act just kicked in. We have only existing legislation that regulates part of the AI life cycle. So you have privacy legislation and you have medical device legislation. We'll mention some here. We do have a document, like a formal document of Israel's policy on AI, regulation and ethics of the Ministry of Science and Innovation, and it adopts the OECD responsible AI principles, which were mentioned in the former presentations, and encourages sector-specific regulation. So maybe unlike the EU AI Act of talking broadly about the main principles, here they say, okay, we understand AI in health is not like AI in transportation, and let's regulate it specifically, but of course this did not happen yet. We do have a couple of initiatives of the Ministry of Health, one document that accommodated the FDA GMLP, the good manufacturing, the good machine learning practices, and some guidances for the IRBs on how to examine AI devices. But mainly we have both medical institutions and startups and companies self-regulate themselves, adopt all sorts of AI risk management policies, I think mainly because they understand they'll be judged. So the ones that go abroad to the US market, to the EU market, they have to align with what happens there legally, or even if it's developed, they have to, be ready. And the ones in Israel, mostly medical institutions, public medical institutions, I'm sorry to say it as a lawyer, but they really care for their patients. They don't want to hurt them. They want to make sure they get good and safe care. So they adopt these policies in order to make sure. So not sure how I get the next slide. Okay, so let's have a few words about the AI and existing legislation. And just let's imagine, I think I'll take one of Professor Cohen's examples on a device or a decision support tool that goes through either colons, or can take moles in the body or in the skin and check if it's predicting some sort of malignancy, and advising the physician whether it's malignant or not, and how should he act upon it. So in most cases, that could be, in certain conditions, it could be a medical device. So we ask ourselves, does it have a regulatory approval? In Israel, we have a very old-fashioned, I don't know how to say it, non-existent almost, formally medical device law from '92, and you do need to register your product accordingly. Not that, of course, it doesn't relate to AI, it barely relates to a software, but this is what we have. And often the hospital would actually examine if it has an FDA approval or a CE approval, and could have some sort of a regulatory permission to use such product in the hospital. But really, I think we need to be cautious here, because when we look in the latest IMDRF, International Medical Device Forum, and its N81 guidance, or we look in the draft guidance of the FDA, we see very serious thought put into the question, what does it mean to have an AI medical device? And I was awed by the work these two bodies that are, of course, in relationships, and they talk with each other, but what they did and how to interpret AI risks into the medical field, and how to really check what are the data sets. And if someone is interested here in these products, which I think would be very, like in a year probably, would be the way regulators around the world with this and that tweaks and differences, but this is the way AI tools would be examined. And when you look, they really have this model card, which you can imagine as a nutrition label, I think you said. And each AI device tool will have sort of nutrition label saying, what are the data sets? Who are the intended users? What are the indications of use? Where does the device exactly, if we think of this decision support tool I was talking about before that predicts malignancy, where exactly in the workflow would it be plugged in? What risk do we have from being plugged in just before the physician's decision? What is the clinical benefit? What kind of populations are represented in the former clinical trials? And really, if you have all of this information, which Vera correctly say, in a certain model and a certain presentation might cause issues of secrecy, of problems for commercial secrecy. So, but if you will have all this information, you can actually examine it, whether you're a hospital, whether you're even a patient wanting to examine if what they did to you was correct, if maybe you belong to a population was never represented in the clinical trial. We know that oncology protocols are very specific or very personalized. So this is something that when I say mind the gap, I mean the regulation is getting there, but it's not there yet. Whatever is AI approved, whether in it.
Is it possible that we're not hearing Tamar?
Huh?
Yeah. Tamar, something.
Can you hear me better now?
Yes, you're back.
So I just wanted to say that the gap there is something we need to take into consideration. Now, back to Israeli law, if the device was not approved by a regulator, it requires an IRB, Helsinki Committee approval, and really the Ministry of Health issued a guidance there. So we have some really experts on privacy, so I'm going to go through very quickly through this slide so not to make any mistakes, but I'll say there's a new law in Israel, a new amendment to an old law regarding the protection of privacy. I think we all understand that health data is sensitive. It's really emphasized there that even pseudonymized data is personal data and should be protected. When I say pseudonymized to the non-lawyers, I would just mention that it's coded, so the hospital or the medical institution knows who's the patient, but the supplier or the developer do not. And we, of course, have very sensitive unique legislation that have to do with genetic data and biometric data. So this is, again, when we look at the AI lifecycle, we have to check the existing law. We have specific Ministry of Health secondary use of health data circulars, which deal with the tension between research and privacy and are very hard to understand. But that's why we lawyers get some business to be done. So I think the interesting thing to talk about is really the Patient Rights Act, because the Patient Rights Act, which was published in 1996, was amended several times since then. But it's like the Israeli Bill of Rights, and it talks about basic patient rights such as informed consent, which Professor Cohen elaborated on. And really, we have here a lot of questions. What do doctors need to talk to patients about? Now, one of the doctors asked me about certain predicted device. Why do I need to tell the patient I'm using it? I'm making the decision. I'm not telling him that I looked up the book or encyclopedia, or I Googled it, or I talked with an expert. Why do I need to tell him I'm running it through a device that tells me what's the right diagnosis? So I think everybody knows nowadays that this is a thing to do, that this is part of informed consent. It should go into the medical record. But this is really to say, we have many issues here. What does it mean to be transparent about it? Okay, I told the patient I'm using it. What do we know about whether those predictions were done on populations that he belongs to or does not belong to? What do we know about the results of the testing of these data sets? So the fact that the device itself was approved doesn't always tell us what the patient wants to know in order to make a decision. And I think also the liability issues are really valid here. I want to mention also the prohibition on discrimination that is included explicitly in the Patient Rights Act, and really gives us, I think, a tool to discuss AI bias that was mentioned before. And how do we judge AI bias? Oren, Amir, and I belong to this group that tried, I have to say, not with a lot of success, but really tried to think, how do you examine bias? If we in Israel receive AI-based tools from different countries, mostly from the USA, probably with populations that are different from us. So of course, the physicians among us will say, okay, but that's what we did all these years. Like, what's different? So I think what's nice is that AI really lets you ask yourself questions about the way you did things before, because it does change things. So there are great articles about how to do multi-calibration and other data science ways of tackling bias. But I think this is still a question that we cannot always answer. And they were given, that we had here in the forward presentation, several examples of bias that you cannot overcome. So this is really something that I think, not just a mention of bias, we have here in Israel certain equity issues, right? That people from different populations, maybe from Arabs and Jews, periphery and center, that get different health services, that they have different access to health. How would that affect them? Would we use the same AI tools in the different hospitals? How do we make sure that the AI is not used in a way that will actually enhance the gaps? So these are, I think, very valid questions that unfortunately regulation doesn't really answer, but just gives us a value or a direction. And the last, I think, question is to say something about the Physicians Act. And we have several other legislations that talk about health professions, physiotherapists and others. And the question is, can AI replace the physician or the professional? And I think the answer that in Israeli law, we say, same as in the US and in Europe, that really we need human supervision and we need the human to make the decision. But really a very valid question was, until when? When will we get to the point that we'll say, okay, we need more psychiatrists than radiologists. Let's let the AI do radiology because it's like 90% or 95% right with examining x-rays or examining other. So this is something that I think future us would have as a issue to talk about. And I would like to end my presentation saying something about AI risk management, because in a time of uncertainty, when existing laws are all we have and they're just giving us the minimal base, but they don't answer fully the AI challenges, I find that many bodies, whether commercial or medical institutions, talk about what they can do to mitigate risks. And really, they try to go abroad and they try to look at how things are done differently. They have different motivations, right? Like foreign companies would like to show their investors and the due diligence process, and they have commercial agreements with big companies. So they'd like to show them that they have an AI policy. And medical institution really would like to guarantee their safety and to enhance patient trust and physician trust. We don't talk a lot about the physician as people who are also affected by the AI systems. So we have, I think what we usually do is take the AI risk that were mentioned before, and the different responsible AI principles, from privacy to human supervision to safety to discrimination to informed consent, and see how we can actually implement it in the same AI tool or in the same process. I think different opportunities and concerns are still to be dealt. I'm not sure regulation and regulatory measures are the best ways to deal with them, but we need to talk about the impact of medical teams' well-being. Is it good for them that they have more and more AI tools, right? That we would like to think that it provides help, that it will help with burnout of medical teams, but maybe it adds to it if they have many tools that do not interact. That I don't know if they usually have the right training for that. We don't want to throw the water with the baby, as they say. And also on patient perspective, when does it serve as patient empowerment? When does it serve as something that can be chaotic or disinformation for the patient? So I think this and the effect and the therapeutical relationship is something that we should take both as an opportunity and concern. And again, I'm not sure regulation is the best tool to work with regarding these concerns, but I think at least we need to make sure that the regulation works in the right way, that it enhances the right things, the medical team's well-being, the patient's autonomy and empowerment, and protect the therapeutical relationship and not vice versa. So with that, I finish my presentation, and thank you all.
Thank you very much, Tamar. And so now we are going to have a kind of an open discussion. You're more than welcome to raise your hand, which is somewhere below. You have this react option and then raise hand. And so once we'll see some hands up there, we'll call on you, and you're welcome to ask your questions. I want to, for now, use my prerogative as holding the mic, and say, so we have people from different fields now, including regulators, people from cognitive psychology, experts in bioethics, medical doctors. We're not a big group, but we are a very diversified group. And I think many of the things you talked about would be looked at differently from different perspectives. But my major thought is, maybe the question I asked before we met today is not that relevant. Maybe listening to you all, and I wonder what you think about it, it's not really that much about adding new regulation, but rather in the practice of medicine and healthcare generally, how do we interpret maybe the new reality or the new things that we're starting to use? How do we interpret the operationalization of the various values and concepts that we've already thought about many years ago in medical ethics? How does it translate differently, or how do we do it in a way that we feel that we're doing our best? Am I getting it wrong? Like, do we really miss legislation here? And without it, maybe things could go very awry, as they say. Maybe they don't say it like that, I don't know, but very bad. What are your thoughts? Like, because is it, and adding to that, like, where do you think there's over legislation or maybe not enough legislation? Because I'm kind of wondering, what do you think about that? So, yeah, Vera, your thoughts, maybe?
Me? Sorry? Yes.
Yeah.
Well, look, I'm not, of course, everything that we say right now is like being Nostradamus, because at least in Europe, I mean, for all of us, we are in the beginning of that, right? And especially in the EU, talking about if you have excess of regulation or not enough, well, not enough, I believe no soul in this world would say that. But if it is an excess of regulation, of we got it on point, I don't know. Time will say. So I don't know in the sense of having data and saying, yes, I'm absolutely correct. I do have a feeling. And my feeling is, well, making an analogy with the GDPR, is that we went a little bit too far. Now, if you ask me, would I rather have the US model, because for us in Europe, the US model is considered like the most liberal, especially with the Trump administration, probably with the different government will be different. No. Because even though I love innovation, I'm a total geek in this sense, but not innovation at any price, like having innovation just for the sake of innovation. Something good gotta come out of it. And I don't see it that in this approach. Now, I do find very interesting, and I think it's a pity, Oren, it's a pity that we don't have anyone from the UK. Because I'm curious about how the UK will develop, which seems to be a kind of an in-between between the US and the EU. I was disappointed that in the Paris summit, they didn't sign the declaration. I guess they were, like blinking the eye to the US. But I think the UK probably has a good approach to it.
That would be interesting. We might consider having someone from the UK in our next meeting then. And so thank you, Vera. Glenn, do you have any thoughts? Like, are there any black holes, loopholes that need to be regulated? It's really lacking.
So what I'll say is, we've got a category of things that FDA reviews. It's small. We've got a very large category, especially of hospital-based things that FDA never sees. And it seems to me that that's either good or bad, but like, it's not exactly how I would make the cut. And I think, in theory, Europe has the right idea, was this risk-based classification system. In practice, defining the risk, especially if you don't have other statutes to point to that automatically kind of put you on the inside, I think it's very hard to do. But in reality, I think everybody agrees we should have maximal regulation and review of high-risk applications, low risk applications, low review, and have lots of kind of development. But I think that where FDA has landed is the piece of it looks at is tied directly to the definition of device, and then things that Congress has kind of carved out, including decision support, that I don't think are necessarily the most rational way to do it. So I would be much more worried about the heterogeneity of hospital-based review. And then I'll say one other thing, which is, I'm not a competition law scholar, but the DeepSeek stuff makes me feel a little bit better maybe, but I am very worried about the idea that we've gone from having a huge number of players, you can be a small, scrappy startup and produce something really good, to a world where there'll be 4 foundational models and everybody will build on top of that. And in particular, in the United States, the way electronic health record systems might become the dominant place where AI is implemented, such that they have the keys to the kingdom.
Yeah, thank you. Glenn, Tamar, if you have something on that matter, then I'm happy to hear your thoughts.
Not a lot, just to say that I think that regulation is very fragmented. We have, like we said, either it's hospital-based, institution-based, or products-based. And AI is causing a greater change in everything, in how we interact and how we live. And we're just in the beginning of this change. I don't know how the grandchildren of whoever is here in the session would interact daily with certain, 3D cameras, VR, whatever artificial world they will live in, and how healthcare would look like it. But I assume it would be very different.
Right. So, we're going to do a conference next month at the end of March. So it'll be our first conference. It's a real conference where we meet each other after 2 years of doing these events. And one of the things we thought about discussing in it, how we change medical education, because it's changing, right? I mean, I'm doing some courses right now. and I have to use AI because, I mean, as a student, and it's amazing what you can do today, right? As long as you realize that it might not be perfect, for practicing, for doing simulation, for other things. And that might lead us to questions that are not necessarily legal, but what is the vision of the future healthcare provider, or professional, doctor, nurse, whatever? I mean, we have the vision of the expert. Why should it change? But if some things that are basic to what you do are going to change, then maybe we need to think about what it means to work in a profession, right? And these are, I think, questions, ethical, professional questions that, while they're not necessarily regulated or need to be regulated, they do relate to what does it mean to be a professional, which I think is one way of thinking about ethics. Now, what I do want to ask you is about the aspect of democratization of knowledge. So we talked about the medical field, we talked about hospitals, we focused on medical devices, but you, Glenn, mentioned also the well-being sphere, for instance, right? Now, you know, there are so many well-being apps, like there are, I don't know today, but there are potentially more than 15,000 mental health related apps. They are under the umbrella maybe of well-being because it's easier to look at regulation that doesn't look at mental health, right? And then I will connect this, and we wrote a paper about the democratization. It's amazing. I can have a model. I have a model on this computer here, a local model. It's wonderful. If I put DeepSeek here, which I did, and I ask it about what happened, you know, in a specific time in China, it says I cannot answer this question, right? If I ask ChatGPT, it will answer the question about the Tiananmen Square, but then there will be other biases that it might have. So even if it's local, maybe my data is protected, but some biases are going to be there. But having said that, it's wonderful, right? Everybody can use it. It's very accessible. Now, talking about that, let's think about the EU AI Act and its levels of risk, where, at least in the past, I think chatbots were considered low levels, and those that could discern emotions and even deepfake, they were considered medium level. I'm not sure it changed over the past year. Now, having said that, while it doesn't reflect on every case, it's just one lawsuit in the US, the one against Character AI, where obviously I haven't seen the evidence. I just read 93 pages of the lawsuit and so on, and talked to the lawyer that submitted it. Well, it seems like a young boy took their life following a discussion that was leading him or encouraging him, or at least identifying, let's say, suicidal ideation and not doing enough or not doing anything, or even pushing him towards whatever happened, which I don't know how to discern because I haven't seen everything and it might have been edited. It does connect to, does it really fall under low risk? Well, what I'm saying is that it's really hard to decide why would you say that something is low risk or medium? I mean, it has to change from case to case. So in a way, what I would do if I look at the EU AI Act, I would consider saying that it's a recommendation that these fall under certain risk, but if you show specific aspects of the case, it might be considered that it becomes higher risk. For instance, I don't know, it needs like there's some work to be done on flexibility here, and it's very easy to be kind of critical about legislations that others worked on. It's so hard to legislate, and it's so easy to find the problems in a legislation. So maybe it's a good thing that we have an EU AI Act, because it's something to start working on, right? Like globally. You've pointed into some issues you see there, Vera. I know you don't have a long time, but I'm just wondering if you have something to say about that before we say goodbye.
Yes, indeed. I apologize in advance because I do have a late class here in Lisbon, and so I need to go, but quite very quickly. So yeah, indeed, chatbots are considered low-risk AI systems, and transparency obligations apply. Transparency obligations in this case are still relevant because that means that when the young boy or whoever is talking with the chatbot, it must be made completely clear that this is a machine, is not a human. So is transparency in that sense, but not, however, which I will not say that will solve the issue, but it's an important information because we know how children and teenagers sometimes get a little bit overwhelmed and they cannot distinguish what is tech, what is digital, and what is real, right? Even sometimes myself talk with ChatGPT as if it were a person. Okay. Now, the other thing is that if the chatbot is based on a generative AI, as it is the case of ChatGPT, so it is chatbot like ChatGPT, the matter is different because not only transparency obligations apply, as it will be the special rules on generative AI apply, on general purposes AI system, they call it general purposes AI system apply. And there's a division between the ones that have systemic risk and the ones that have not. So now you will say, well, so such a system probably will have systemic risk. Now that's the tricky part, because unlike all the other parts of the AI Act, the definition of systemic risk is not related to the risk to health, safety, or fundamental rights, but with the computing power that was used to train the AI system. So here the AI Act suddenly switches direction and starts a division or a classification of risk in an entirely new way. And depending on the on how many flops were used to train the AI system, that will dictate if it is a systemic risk or not. So it gets pretty complicated. Well, I don't know if the AI Act will create the Brussels effect. I'm pretty sure Brussels is counting on that. Not sure. Only the future will say. And I'm really sorry, I need to go because my future is on my class of scientific publications. Thank you so much.
Thank you so
thank you,
much.
Oren, for inviting me. Thank you all.
Sure.
I wish you a wonderful event and we talk later.
Thank you, Vera. So
Thank you
so much. So we
Bye-bye.
still have 11 minutes on our clock. And I just wanted to get the EU perspective. And I think, so Vera was alluding to anthropomorphizing of the system, right? So basically kind of attributing human-like traits to a non-human. And while maybe looking at Turing's test in a way, it's nice to have something that might respond very similarly to a person. Maybe you couldn't know the difference, but here it's not about, I don't know if it's true or not because it's a test that we're doing. They're not telling me it's a person, which was not the case there. And you know, and in this specific lawsuit in the US, they're claiming that, well, the boy knew it was not a person. He told his mom, I know it's not a person, but at the same time, he acted in ways that maybe were related to the connection that he was creating with that, whatever it is, this new being or this new thing that we can interact with and might fill in some holes in our psyche or our psychological needs. I don't know. And so again, I guess the risks are so diverse and they are hard to calculate when we think about what should be a part of that. Questions, thoughts on part of the people in the audience, because I'm sure there are many. So if you want to raise your hand or open the mic and ask something, then you're welcome. So you talked about torts, Glenn, and obviously talking about risk, a lot of that would be related to people asking for damages. Now, let's talk about, even in Hebrew today, there's some really nice AI tools that do kind of an improvingly better transcription. It wasn't that good in the past, right? Transcription, summarizing, and so on. And people are working on that open source to improve it much. Now, we tried that in the ethics committee in the hospital that I'm working. It went really bad. So I didn't know I didn't know what to do with that, right? But at the same time, what happens when it's so much better? It sits there in the background. It listens to our talk or to the meeting with the patient. And instead of the typist that we have today, let's say in psychiatric committees where I reside, it would probably type faster and more accurately, potentially. But what happens when there is a discrepancy between what has been written and what I remember that happened, but not at the very moment, but maybe a week later, 2 weeks later? Like, I mean, if people are going to check that, then what's the use of AI? I mean, if you want to have a person in the loop, is it really saving time? And if you don't have a person in the loop, then who's going to take responsibility? I mean, it sounds a technicality, but I'm wondering if you have some thoughts on that, Glenn, and and Tamar. Obviously.
Yeah. So great. So you're writing my research agenda for me. I just put one paper in the chat in Egypt AI that we just did on the case you mentioned before and this question of humanization of AI as opposed to disclosure. We have another paper, I think, coming out tomorrow in JAMA Open Network on the question you just asked, which is what happens when there is digital scribing and the physician does it stay in the medical record, and what happens when there is discrepancies related to medical malpractice, and what are the best practices. Now, that article is written mostly from the perspective of hospital systems, what they should do to protect themselves, and the idea that there should be only one medical record. It should always be the final. It should be reviewed by the doctor, and you should not have both floating around. Questions about disposing of the other one in a normal sort of way, not in a motivated sort of way. I will say that the evidence on automation bias suggests, and this is, I've looked for a citation for this, couldn't find it, but people I know tell me that what they've seen is that essentially after, basically 20 instances, the individual, the physician gets much more automated in terms of their reviewing, and the chance of actually catching errors is highly reduced. So like the idea, if your mental image is that the physician's going to read all the notes and catch the tiny mistake, it's not going to happen. Now, that said, it turns out the quality of scribing done by physicians with patients is not great. They're often dividing their attention between typing and looking up. Even human scribes, which might be added, make difference. So it's not a question, you can't have everything. And the real question is, what percentage of cases where errors do accumulate are likely not to be caught further down and are likely to cause adverse events? But there's also other spaces where for purposes of efficiency, we've decided to produce a care episode that it's less than the maximal, but might be the optimal. And I think this is going to be another instance. But if you think that the idea is the physicians are going to be carefully reviewing it, as you say, then you're just doubling the work, you're paying for the expense of AI, and you're having the physician do it. The physician's not going to be very good at catching the errors. So I don't think that's going to be the future. We should just bite the bullet and realize that some of these documentation errors will occur. And maybe there ought to be kind of a socialized compensation if you're related to one of these, rather than having a malpractice trial that you get, turns out if this is the size of the injury, the makers of the AI put it into a fund and you're paid out from the fund. That might be a rational way to do it, but who knows? Large academic and medical centers can afford to do the vetting and can have the expertise. Small practices cannot. And if a regulator doesn't give a seal of approval, or a non-governmental body doesn't give a seal of approval, or isn't easy to implement, suddenly now you have haves and have-nots within the profession, not just about wealthy patients versus poor patients, but your corporate organization and the size of kind of your design. And that's something that I think is like a reality of the future economic organization, to the extent AI actually adds value. If it turns out it doesn't add value, it's just a bell and whistle. You don't have like a million other bells and whistles. But if it adds a lot of value, now all of a sudden there's this question about the diffusion and dissemination. But like I said, I'm curious to hear what Tamar thinks.
So I think personally that that it's a lot of like in psychotherapy, it's a lot of an issue of trust, because the legal issues are very simple, right? You have certain privacy standards. Again, I wasn't sure if you were practicing in Israel or in the States, but let's say that 80% of it, both. Let's say 80% are probably similar, not all, but 80%. So you do have certain data security issues that you need to comply with, and doesn't matter. Unfortunately, it doesn't matter if you're a small, physician or like in a big institution. But I think AI-wise, I think what I find personally a little bit disturbing, and I'm not sure everybody's aware of it, that when you use anything commercial, and specifically I talk about, not being in a big hospital that has a legal department that goes through, but you as a certain, a lone physician, and you have certain policy, which is usually, you can't change, you don't have a negotiation power to change the contract, right? You'll take one tool, either it has a regulatory approval or not, or maybe it doesn't need a regulatory approval because it's more of a wellness thing. And then you'll go through the policy. I'm afraid to say it will be difficult for you. It's difficult for me as a professional in Israel to go through and to assure you. I usually see the loopholes, right? And sometimes the loopholes are legal because all they require is patient consent. And then you can ask for patient consent and you can consent as a user. And that would be legit. But then, you could have consented to something and they could have consented to something that maybe you would feel less ethical with. like, moving your information or his information this way coded or that way coded. So I would be very cautious. I don't want to say go to legal advice because I'm not sure that one person should, but it has to have great benefits for me, it should have great benefits in order for you to make the effort and to remember that law is not aligned totally with ethics. I'm afraid to say that too.
And also that interpretation is an endeavor that could lead in different directions, and therefore one needs to maybe apply their best ability to think about what is correct in the sense of what is professionally correct, how they view it. But so really, thank you, Shira, for sharing, because I do think that it's very easy and very, I would say, even typical of us as jurists to sometimes discuss issues in a very intriguing manner that is hard for others to maybe even fully grasp, not because we're that smart, because we use our own language or terms and concepts and so on. And that's not a good thing, because it does mean that in some cases it's so hard to understand, is it legal, is it not legal, what are we supposed to do? And I kind of suspect that maybe in some fields it's intentional because we don't know. But that's just my own take on that. But what I want to say, there's a place in Jerusalem, it's called Holy Bagel. It's a funny name, right? And so I was thinking about, because I look at a bagel, I'm so hungry, I only see the bagel, but you can also see the holes in it. And it's, the half full and half empty glass is an issue here. And here's the thing, it's so exciting what we potentially can already do. And then the questions are, so is privacy really such a big deal? If they write on the website, HIPAA compliant, what does that mean? I don't know. I've seen that. What does it
The
mean?
best, Oren, is when they say HIPAA compliant in Israel and HIPAA does not apply in Israel, but GDPR compliant in the US, which makes no sense.
But if it's HIPAA compliant in the US, then, and what I'm saying is that really it's also about how risk averse people are, but that's, I think, a matter of maybe we should organize things more in this regard. So I think what Glenn suggested is a good idea, that professional organizations, instead of waiting because people are already taking their cell phones and using them for different purposes, right? Now, with all the open access stuff, and some people use 4 or 5 different engines because they want to compare, and it's really cool. But to what extent are we maybe using some information that can compromise some privacy? I don't know. And I think so. Education, that's a big word, right? But not just patient education, but professionals education as to the risks and the possibilities and the implications of sharing data and so on. And potentially maybe not as guidelines, but even soft kind of documents that give general ideas as what you can use and what you should not use. I think it's still missing in a way here in other places as well. So maybe what is important to kind of translate the wonderful papers that a lot of us are maybe writing into very easy to digest, useful information for healthcare providers. These are my thoughts. Any closing remarks on the part of the speakers, and then we'll thank you. Thank you everyone for joining us at this late time of the day. I want to especially thank the speakers. I really enjoyed your talks, and I think it was very informative and more than that, and creative. And I hope we can keep working, maybe even together on some of the things that were mentioned here, because it does seem that the challenges are not local; they're global and they're similar. And if anybody has a great idea, we should kind of use that in other countries as well, if it applies there. So thank you all, and we'll be in touch and invite you to our next event. Thank you and good night.